You'll be able to see discovery or the evidence against you as soon as your attorney receives it. Now, there are some rules, for instance, in state court in Texas, where the attorney can show you the evidence but is unable to provide you copies. There is some evidence called contraband evidence, which you're only going to be able to observe with your attorney by going to the law enforcement agency that holds it. But at all times, it is your right to know the evidence against you and be informed of that evidence before your trial begins.
Good. And let's
I frequently use experts in my trials because my job as an advocate for you is to educate the jury, to make them better informed, and let them show that we more accurately understand the facts than the other side does. So I will bring an expert in order to tell the rest of the truth that the government, the state, has failed to show. Sometimes I simply use experts to educate me so that I ask questions of the other side's witnesses in the best way. In fact, oftentimes the best case is when the defense puts on no evidence and we prove our case through the government witnesses, which sometimes is done with the aid of experts as consultants.
trial.
If your case is going to trial, you should expect a lot of preparation. 90% or more of work on a trial is done before the trial. 3 key principles of trial success is preparation, preparation, preparation. You are key in that process. You're going to be the master of the facts, and your attorney is going to rely on you to find the best witnesses and to know the questions to ask of all witnesses, both the government or the states, as well as our own. And even in preparing your own testimony, should you choose to testify, you are vital to case preparation, and you should expect to be fully invested in it. To talk about sentencing can be confusing if you're pending criminal charges. Certainly for those who know they're not guilty of the charge, it seems odd to be talking about sentencing. But I've also found clients often talk about sentencing as if it is inevitable, when if you go to court and plead not guilty, the whole point is never to get to sentencing. That being said, you always have to be prepared for sentencing. Certainly in a state court or a military court, sentencing almost immediately follows a verdict if the verdict is guilty to any of the charges. So you have to be prepared with character witnesses and information about you, and even information about the alleged offense to show matters we call mitigation or extenuation. Now in the federal cases, there's usually a 3 or 4 month lag in time in which, if there's a guilty finding, there will be a sentencing hearing in which, again, we will present information about you, about your life and your accomplishments, and even about the offense itself, to convince the court not to sentence you more harshly than is just, and to show clemency and mercy as well. People come to our law office because they're looking for strength. They're looking for integrity, and they're looking for intelligence to tackle any challenge or obstacle before us. Because in our law office, winning isn't everything, winning is the only thing.